I think it was Sam Altman that came out and said, I just don't understand why it is that people are oversharing with these chatbots, because none of that stuff is guaranteed to be private.
I've named my ChatGPT bot Jose.
You really are obsessed with me, so that doesn't surprise me at all. God forbid you get sued in the future. It's going to be discoverable. One jurisdiction that made a determination that those chats were perfectly discoverable. Another court in a different jurisdiction said no, and that's work product.
Where do you think it should go?
It depends on who I'm representing.
Good lawyers will always think of good arguments.
From my perspective, the best lawyers in the country are right here in South Florida practicing alongside us.
I think we have a very aggressive bar down here.
But this makes me think about whether or not litigating in Miami is different. For everything that we say about the customs here, practicing in South Florida.
It took me a couple of years to kind of start understanding some of the cultural nuances of life down here, but it's pretty special and it's going to be in play forever.
So, welcome back to Courtside. We are here in the historical Miami-Dade County Courthouse in the ceremonial courtroom where Al Capone was tried. Incredible history, but this makes me think about whether or not litigating in Miami is different. That's a horrible transition, but let's go with it.
No, I'm with you, man. I love this room, and I gotta say, I kind of love this courthouse.
Yeah.
I did hear a story once of a lawyer who put their file on the sink in the bathroom, and the sink fell off the wall. And then, of course, you've got the asbestos. But besides that, I really do love this building.
There's an incredible amount of history here, right? I mean, forget about this courtroom for a moment. We have water fountains out there that still have the signs that say, for colored people only, right? Those segregated water fountains. There's history in that, right? This building is 98 years old, and here it is. It's still standing right in the middle of Miami, one of the most dynamic cities, arguably, in the whole entire world. And it's kind of weird to be here today because we're sitting in this empty courtroom where just weeks ago, it was a thriving courtroom. I mean, there were trials, there was a jury here, there was a judge standing up there.
I think you tried one of the last cases in this courthouse.
I tried one of the last cases in this courthouse
That's
at
amazing.
the end of last year.
Yeah.
It's funny because we tried before that judge, one of the last case that he tried in this courtroom, and now we're going to try in 2 weeks, the first case he's going to try in the new courthouse.
This is what it looks like to be a trial lawyer.
So that's what it is. I mean, that's the difference. But I really do want to talk about Miami. Take the opportunity to talk about Miami as a jurisdiction, Miami as a venue for litigating.
Yeah.
And what I mean by that is really, I'm licensed to practice law in Washington, D.C., and I'm licensed to practice law in New York City. But I would never dream of filing a case in those jurisdictions without having local counsel.
Yeah.
I mean, you've practiced in New York, and I was telling you a story before we got on camera about a hearing. I traveled for a hearing. Again, I'm licensed to practice in all of the courts, state courts in New York. I traveled for a hearing to New York, and it was almost like they were talking a different language.
Yeah.
I just didn't understand what they were saying. You had to go to a little room to get a piece of paper to come back, present it to the judge. It was just crazy.
Yeah.
So talk to me a little bit about that.
Yeah, the way that I always think about litigating in any jurisdiction is there's really three components that you have to be fluent in. Number one is you have to know the law.
Yeah.
Number two is you have to know what I'll call sort of the mechanics, right? Yeah. What you're talking about is the piece of paper, right? I remember when I started practicing down here, they would have this stack of blank orders, right? And you would kind of need to know, okay, here's where I take the, remember that?
Yeah, I remember. You fill it in.
Triplicate, and then it would
carbon copies,
right? Exactly, right? So I'll call that sort of the mechanics or the logistics, right? Where do I stand? Who do I talk to? Where do I check in? Those kinds of things. And then there's the soft stuff, which from my standpoint is probably one of the most important things because you could kind of learn the law and you could sort of muddle your way maybe through the mechanics, but that soft stuff takes a long time to build. And,
I mean, I think that's absolutely right. You hear lawyers talk about hometown, getting hometown all the time. And and that's true. It really is true. And it doesn't mean that the judges are going to rule against you because you're from some other place. That's ridiculous, right? But it does mean that you have to build some sort of credibility before that judge that has never seen you before.
Yep.
So most of the judges down here, whether it's federal court or state court, we appear before all the time. They know us. We go to events together. I mean, that's true for the bar, the entire bar practicing down here. It's not just unique to us. But when you go to a jurisdiction, I mean, I had a hearing in Jacksonville, and incredible judge, incredible opposing counsel, but I had to start showing that judge that I was credible. I didn't take any leaps or any aggressive positions because I needed to establish, hey, judge, you don't know me yet, but I am credible. I'm not going to tell you something about a case that isn't true. I'm not going to misrepresent a fact. None of that stuff. And that's the type of credibility that those local counsel, those great attorneys that were opposing me in that case, they already had with that judge immediately because they've appeared before that judge hundreds of times.
Yeah,
right?
and you know, clients, sometimes it's a little bit of a hard sell to get clients to understand why local counsel is so important, right? Because their view is, well, hold on a second. Number one is, I feel like I'm right. So what difference does it make if, you know, who's arguing this case? I feel like I'm right. And number two is, isn't the judge going to just kind of call balls and strikes here and going to be an objective, you know, purveyor of the facts, and wherever the chips fall, they're going to fall in my favor kind of a thing? And it's just not how it is. It's not how it is. I mean, first of all, there's so much gray in what we do, as far as it's very rare for any true complex commercial litigation case to be very clear cut. Right? I mean, good lawyers will always think of good arguments to make adjudication fall into a little bit of a gray area. And when you're in front of a judge and you're trying to litigate a gray issue, man, that credibility matters a lot.
If it wasn't for these gray issues, we wouldn't be in court, right? So that's the assumption. Most of the stuff is gray. What would you say is the most common mistake that out-of-town lawyers make when they come into our courts down here?
Golly, I'd say the most common mistake is they underestimate the local bar. I think when out-of-town lawyers come in, and look, I cut my teeth in New York, and I litigated with one of the best firms in New York, and adverse to some of the best law firms in New York. And granted, this was 20 years ago, but there was a sense that attorneys in Miami were sort of provincial, not very sophisticated.
Right.
And first of all, the bar down here has changed tremendously, and I think there's a real level of sophistication in the bar down here that maybe was not quite as prevalent 20 years ago, although there were, of course, pockets of excellent attorneys down here even back then. But more than that, these guys come down and gals come down from other jurisdictions, and they think that they're going to be able to steamroll the bar down here, and they're wrong. There's incredibly talented lawyers down here, and like I said, those relationships really matter. What about you? What do you think?
So, you know, one of my favorite things is the dysfunction, if you will, and I say that in a loving way, of the divisions of the court. So we have about, I guess, 70 judges total, and I would say maybe half of those are in civil. And by and large, each of those judges has a different standing order, right? Different requirements, different things. So if you're just coming into South Florida and you're assuming, you know, this particular rule applies for everybody, you're wrong. I mean, judges have different things, different ways they want you to schedule hearings, different documents that they want you to provide, different ways that they want you to provide these documents. So it's those little things. It's those little things that when you're coming into a jurisdiction that you need to be aware of, because it changes your perception, your credibility. I mean, I think that is a huge, huge difference with other jurisdictions.
Yeah,
right?
and it's funny. We have folks in our office that have really good relationships with the courtroom staff, the deputies, the judicial assistants, you know, et cetera. And again, it's not. It's just one of those things where having that kind of level of access, that level of information, that level of comfort. Right, with that part of the system just makes a huge difference in our cases.
No, it's huge. It's absolutely huge. Just in terms of getting hearing dates, for example.
Right.
You know, here, if you want to get, with some divisions of the court, if you want to get a hearing date on a specially set, meaning more than 5 minutes, it's 2 or 3 months down the line, if not 5 or 6 months down the line. But the ability to be able to call your friend who's a judicial assistant and say, hey, can you squeeze me in a little bit earlier, right? You know, if something shows up, can you give me a call? That's huge.
It's huge.
That's a huge advantage, I think.
But your point about the sort of the local rules or the local processes for each of these individual judges. I mean, a lot of out-of-town lawyers don't even know that. Even in the state court, which is now handling some of the most sophisticated commercial disputes in town, a lot of these judges have kind of buried on their website, and these, you know, and sometimes they're not even on their website. What it is that this judge likes. Do they like hard copy binders? Do they like electronic binders? Do I upload these to CMAP? Do I send these to the JA directly? You know, there's a million little sort of pitfalls, really, through that process that I think is one of the main reasons that local counsel
And I
is so
think
valuable.
you hit the nail on the head when you said sometimes they're not even listed on the website.
Yeah.
Because if you're trying to get guidance, sure, there are some rules that are listed there, but you just know the judge. You've appeared before them for 2 or 3 decades. You just know what they like.
And let's talk about what judges like, because I really this concept of the humanity of the judges is so interesting to me as we kind of think about AI. And you and I were actually working on a case recently where a judge expressed sympathy for something that happened to our client, and it wasn't disputed that this happened to the client.
Yeah.
And the opposing counsel suggested that that was a basis for disqualification because of that expression of sympathy.
Yeah.
That feels crazy to me. And I wonder whether so part of it is, of course, sour grapes, right?
Of course.
This attorney lost it because we kicked his ass and he got mad about it. Fine. But then I wonder whether are we just living in a world where we don't expect our judges to be human anymore?
Yeah, and I mean, I think you're raising, 2 points. The second one of which I'll get to in just a moment. But the first one is, judges are people.
Yeah.
Right? Judges are moved by compelling situations. They're moved by compelling facts. And although we may not like it, judges will tell you that they bring into the courtroom their own prior experiences and judgment and, biases, if you will.
Yeah. And you took some heat for making that kind of comment before on this podcast.
Yeah, that's exactly right.
And it's like, come on, dude, like judges are allowed to be humans,
Yeah, and you know what would surprise me about that? And by the way, the comment was that judges, precisely what I just said, that they come into the process with their own personal prejudices and biases. And it wasn't a criticism of the judiciary, it was simply pointing out that judges are humans. And that was made in the context of a discussion about whether AI models might be better and more objective fact finders than human judges, just to kind of be provocative and provide for the conversation. And people got upset by that. They felt that it was disrespectful. Right. Exactly, there we go, right? But I guess getting back to the point, I don't think any judge will dispute that they're just human beings.
Yeah.
There's a very, very good judge, and several years ago he was, let's just say, slated for a promotion, but ultimately what dinged him was that, he got emotional during a trial. It didn't affect him. It didn't affect his ruling. The criticism wasn't that he made a poor ruling. It was that, he kind of got teary-eyed when he heard some of the testimony, and that sank him. And I think that's just horrible. That's a horrible thing.
I mean, couldn't agree more.
Why do you want to take that humanity out of it, right? We were just talking to a judge we were talking about this topic, and his point was really insightful. And it's the system presumes that judges are going to be imperfect, that judges are going to bring those biases and prejudices because we have 2 levels of appeal. And I had never thought about it that way. So I think that's just the reality of the situation. That's something that we should welcome. The second thing that comes to mind about that motion that was filed or this situation that we were talking about is that because the judge made a comment expressing sympathy for a situation that was being described to her, there was a motion to disqualify her.
Right.
Because she was supposedly too biased, right?
But again, sorry to interrupt you, but the crazy thing about this particular fact pattern is that it wasn't disputed. What the judge was expressing sympathy about wasn't like an issue in the case. It wasn't disputed.
It was in the complaint.
It was in the
It was in the complaint. But that raises an issue to me, going back to the local counsel and the bar. Is that too aggressive? Are we more aggressive? Because that's a pretty aggressive position. To file a motion to disqualify a judge, I mean, I've done it in almost 30 years of practice less than 5 times. And it was because I felt that it was really warranted. So, is that too aggressive of a posture? And are we more aggressive in South Florida as litigants, litigators, I should say, than in other parts of the country?
I think we are.
Yeah?
I think we have a very aggressive bar down here. I think that aggression takes a couple of different forms. There's what I'll call necessary aggression, and there's what I'll call, I don't know if unethical is the right word, but aggression.
Positive and negative, if you will.
Sure.
Yeah.
And I think that we probably have too much negative aggression in this jurisdiction. I think that people are very quick to file what I would consider or take what I would consider to be kind of unprofessional positions under certain circumstances. And I think we've got a fair bit of the positive aggression as well. I think relative to the rest of the country, I think that we're on the more aggressive side of the spectrum. Do you agree with that?
No, I think that's right. I mean, I haven't really practiced much outside of Florida other than in the international arbitration context, so that's a different thing altogether. So I don't have much of a basis for comparison. But I do feel that the bar down here is more aggressive, whether it's positive or negative, than other parts of the country. You know, there are states where I've appeared, like Colorado, for example, and Arizona, and I've appeared in cases there as co-counsel. And it just felt like there was a different level of practice. People were more willing to extend, for example, extensions of time to do certain
it's a little
things.
more of a genteel.
It is.
Yeah.
Still very much like a profession, right? That's what you would imagine a profession is. Now, I'm not suggesting that we're unprofessional here by any means.
Yeah.
I love the bar. From my perspective, the best lawyers in the country are right here in South Florida practicing alongside us. Every single day when we step into this courtroom, or used to step into this courtroom, and now we step into the other one, we're surrounded by incredible talent, and I learn from them every day. But it's more of a business, if you will, right? The profession aspect sometimes gets a little bit lost and blurred.
I think that's right. It's, you know, I also think that turning so much of our practice to a remote kind of based practice, I would say maybe 15% of our hearings are in person at this point, maybe, right? Yeah. Somewhere there, probably 85% on Zoom, I would venture to guess. I think spending less time physically next to opposing counsel has degraded some of the professionalism in our business.
Yeah, the digital bravado, right? It's easy to shoot off an email and be really rude or say, but when you're sitting next to that person in court, it's much more difficult to do that.
Yeah, I think that's right, and it's interesting to see if that's ever going to kind of swing back. And I'd also be curious to know if that's something that other jurisdictions are seeing too. I don't know the answer to that. Yeah.
I mean, how often do you practice in New York? Nowadays.
Oh, I when I have a case in New York, I try to get local counsel.
Yeah.
For the reasons we talked about. I mean, look, I'm obviously barred in New York still. I could litigate in New York, but I know, you know, one of the things that I don't think lawyers do enough of is recognize their strengths and recognize where they can use help. If I'm litigating a case in New York, I want help for that, you know.
I'm going to take every advantage I possibly can.
Yeah.
You know, within the bounds of the law and ethics, of course. And if it's going to be more beneficial for me and ultimately the client to have a lawyer from that local jurisdiction sit next to me at a hearing or at a trial, guess what? I'm going to do that.
I could not agree.
Why wouldn't you do that?
I could not agree more.
I just don't understand why people don't choose to do
that.
Right.
And why are you going to pay an out-of-town lawyer? I mean, look, again, I've litigated in New York enough, but if you threw me into a state courthouse in New York City, it would take me a while to get my sea legs there. Why would you pay me to get up to speed on some process issues or questions that a local counsel already knows off the top of their head?
Yeah.
Doesn't make any sense.
For example, down here we have the requirement with every motion, and it's being adopted in other jurisdictions, in most jurisdictions I should say, but before we file any motion down here, whether it's in federal court or state court, we now have to have a meet and confer.
Yeah.
With the exception of very few motions, we have to have a meet and confer. I think that's a great thing.
Yeah.
I think that's, you know, the local judiciary that's imposing those local rules on the lawyers, that's an attempt to bring back that professionalism that we claim is lacking or just has been missed or has been diluted over the years. I think that's a good thing. If you're not from Miami, then you don't know about that.
Yeah. And I mean, there was recently an order from the 11th Judicial Circuit where you have to disclose the fact whether or not you use generative AI with respect to any of your legal research or pleadings or filings or anything like that. And that's a new certification requirement that you've got to put on there. Again, I don't think out-of-town lawyers are going to be aware of that.
Let's pause on that for just a second because, you know, when we got that order, and it's an order from the chief judge here, we kind of chuckled, right? And I know why they're doing it. They need to have some sort of mechanism by which to hold the bar accountable. You know, if you hallucinate a case, now you've violated an order of the court, so it's easier to sanction attorneys, and it should be. You shouldn't be filing hallucinated cases. But I don't know of a single lawyer these days that's not using AI in some capacity. I just don't. Do you?
I don't even think I know a judge that's not using AI. I mean, I think that, look, we're going to get to the point soon where failure to use AI is going to be perceived as malpractice. Failure to use AI. In other words, right, we're going to, if I'm a client, maybe not today, but for sure in the next 6 months, and my lawyer's not using AI, I'm pissed.
Of course.
Because that lawyer definitionally is wasting time.
Right.
And
there's no justification for it.
Yeah, and put aside, and again, I feel like AI is something where you get the page dirty, and you have a responsibility to clean up that page, okay? But man, the notion of I agree with you. Every lawyer that I know is using AI in some way, shape, or form.
Yeah, we likened the new certification requirement to a certification requirement that you're using a laptop or a computer to draft briefs, right?
Because this was not handwritten. I certify
that we use some sort of computer to draft this brief.
It's just one of those things, man. I think it's kind of insane, but look, we're obviously.
But we keep on coming back, no matter what the topic of our particular podcast is on any given day. We keep on coming to AI, which shows you how it's permeating everything that we do. As lawyers.
I've just. It's irresponsible for us not to be thinking about this a lot. So that's, I think, one of the reasons why we keep coming back to it. But to think about where law is really going is it's just an incredible thing to think about. I saw a chart recently which talked about how advanced the technology is versus how much it's actually being used in different industries. And for legal was the industry with the biggest delta between its capability and its use. In other words, it's not nearly being used relative to its capability.
Yeah.
That gap is going to continue to close. And as that gap continues to close, the legal profession is going to be changing faster and faster.
Yeah, look, I mean, lawyers have always been a pretty conservative bunch, not in a political sense, but in the sense of trying to adopt new technology.
Yeah.
I'm proud of us because we have somebody in-house that's designing bespoke AI tools. And I remember when you pitched it, like it was like this idea, and I was like, I don't know that we need it. Remember, I mean, there was reluctance. And now that I see what's going on, I can't imagine not having it.
Okay, hold on a second. That, what you just said, hold on, I want to get a...
Could you please edit this out,
okay,
please?
I want it on a loop on our homepage, on our website. I don't know, man. Like, I think that if you're at a law firm, I think that the exception is if you're hyper-specialized. I think I think for today, at this moment in time, there's a hyper-specialization exception to what I'm about to say. If you're a law firm that is not thinking about AI and how I'm going to integrate AI into my practice over the next couple of years, you won't
be a law firm for long.
You won't be a law firm for long.
I mean, that's just a reality.
Yeah, I think that's right. It's exciting. It's fun. I mean, I'm using Claude Code now to build apps for like my family.
Yeah.
They don't use the apps.
But you're having a fun time doing it.
I'm having a great time using it.
Me too.
My wife's like, I was like, you're not impressed? She's like, no, I'm not impressed. I was like, okay,
my wife doesn't care. And I keep on trying to bring her into the foil. And she's like, it's okay. I don't care about it.
It's frustrating.
It is frustrating. For everything that we say about the customs here, practicing in South Florida, I think it's also important to remember that we have particular norms and customs.
Yeah.
And we talked about this before, where I was trying a case before a jury several years ago representing a public figure of a lot of renown, somebody that was, big sports guy, basketball star. And every day at 3 o'clock during the afternoon break, the judicial assistant would come in with Cuban coffee.
Yep.
And at that point, everybody kind of suspended their roles, and we were just people sitting at a Cuban ventanita, having Cuban coffee and drinking, and that's part of who we are here, right? I mean, between filming sessions, we just had Cuban coffee. I mean, that kind of, I love it. I love being in South Florida because of that, but that's part of the culture that people miss when they're not from here.
It took me a couple of years to kind of start understanding some of the cultural nuances of life down here, and it's true. There's a flavor. I don't even know how to describe it, but it's pretty special, and it's going to be in play forever. It's not going away.
It's the universal pacifier, coffee is. There used to
Well,
be.
yeah.
There used to be a judge here that used to have his hearings, particularly discovery hearings, at 7:30 in the morning.
Yeah.
And when attorneys would get into it and they were really heated, he would say, here's $2, go downstairs, because there's a cafeteria down here in this courthouse, and have yourself a cup of coffee. And he would order it.
Yeah.
You guys are going to go downstairs right now and have a cup of coffee. And Cuban coffee is what they sold.
Yeah.
So yeah, that kind of flavor.
When I first moved to Miami, I clerked at the federal courthouse, and there was a cafeteria.
Yeah.
This was the old federal courthouse where it was the U.S. Attorney's office now, and they stuck the judges in there before they built the new one. And I think on the 5th floor, I want to say, there was a cafeteria, and I'm just some gringo from Brooklyn, Jewish gringo, and it's 145 degrees and 100% humidity, so I'm hot all the time. So I would go to the cafeteria, and the dude didn't speak any English, obviously, and I said, hey, I just want iced coffee. Iced coffee. So he would give me a red Solo cup and fill it with ice and pour Cuban coffee and fill it with Cuban coffee. And I would drink that. This is my clerkship.
Rocket fuel.
I would drink basically a pint of Cuban coffee every morning. And I never used to drink coffee before that. And my wife was like, you're talking really fast.
You're twitching. What the hell's going on?
I was like, I don't know. I'm in a good mood all the time now. It's great. I got just sugar and caffeine coursing through my veins.
That'll do it.
Where have you seen a winnable case get lost?
Yeah, so I guess the easiest example for me to conceptualize right away is when you overcomplicate it, right? Whether it's from the very beginning where you're over-alleging facts that you don't need to in a complaint, but more, toward the trial, and even if it's, a bench trial where you're trying the case without a jury, you're burying the judge or the jury in this complexity when just simplicity wins, right? So I think that's a big mistake that people make when they're trying cases. I think that's a big mistake that people make when they litigate cases. If you can convey something in a way that's going to relate to the common person that's going to be non-trained, common person, the lay person that's sitting in the jury box, then do that. Those things will resonate much more than some sort of technical explanation about the law and how the law applies to the facts. Obviously, you have to talk about those things, but find a way to just kind of simplify those things and not overcomplicate it. Do you agree with that?
Yeah, I do. I do think that's simplicity, whether you're in front of a jury or not. Having a consistent theme that's simple and digestible, that kind of tells your story, I think is critical.
Yeah.
I think another mistake I see a lot of lawyers make is, and it comes from client pressure, the reason they make this mistake is because of client pressure, is they try to hide bad facts.
Yeah.
Because clients are skittish, right?
Yeah.
Clients come to you and they're like, well, here's all the reasons I should win, but like I sent this really kind of crappy email, and I'm worried about this email.
Right.
And
they have 10 different explanations for why you wrote it. But
10 different explanations. They're twisting themselves in knots, trying to explain why they wrote this bad email, or why they sent this stupid text, or whatever it is, or even in the case, even why they did something specific. That doesn't mean you should lose your case. And I think what people get trapped by trying to obfuscate these kinds of things, when really you just got to lean into it and say, yeah, like I did this. This is why I did it. This is my headspace when I did it, and that shouldn't, that shouldn't distract you from the bigger, more important questions here in this case, which are boom, boom, boom. But yeah, like I lean into those bad facts, and I think that it's important that clients feel comfortable and the lawyers feel comfortable leaning into those bad facts as well.
I always tell the clients, listen, I could deal with bad facts, I can't deal with a lie. And the reason I tell them that is because whenever you're justifying a bad fact, it ultimately leads to a lie.
Yeah.
Right?
That's true.
You can only contort a bad email or a bad text or some bad piece of evidence so many ways before the jury or the judge starts saying, that doesn't smell right.
Yeah.
Right? Let's deal with the bad facts. Okay, so you wrote this email. There's got to be an explanation for it that's credible, that you're not stretching the truth. And if it's just that I was really pissed off and I wrote it in the heat of the moment, lean into that, like you said. People will understand that.
And look, documents,
Okay.
documents. Back in the day, of course, we didn't have so many documents, right? Right. We then, when I was sort of coming of age as an attorney, and email really started becoming hot and heavy as far as like the primary method that people communicated. The first case I worked on at this big New York law firm, there were millions of documents, and we would sit there in a conference room and we would go through every single document. That we had hundreds of boxes of documents that we would literally just be pouring through these documents. Now, of course, the technology's changed, and we're really moving a little bit. So number one is, document retention. That's something we could spend an hour talking about, right?
Yeah,
I mean, but even in our cases today, documents really matter. I mean, what you communicate over email, over text, over WhatsApp, it matters.
Yeah, and that's something that I caution my clients about every single day, okay? Whether it's your personal email, whatever it is, God forbid you get sued in the future.
Yeah.
It's going to be discovered.
Man, the stuff that people put on WhatsApp.
Not only that, like even with their families, they'll make a joke.
Yeah.
Okay. Those jokes are going to bite you in the ass because they come across as either, completely inappropriate or misogynist or racist or whatever it is.
I mean, I had this experience recently with a client who we had a very winnable case on the law, but man, some of the stuff this guy would put into text, and it was one of these examples of where we kind of leaned into it and we owned it, and that was it. And but it makes my job harder. It makes my job harder.
For sure. And the sheer volume of evidence that we're sharing every single day.
Yeah.
I mean, just think about it. From the moment that you wake up, you'll check your social media accounts and maybe respond to a message within that app. And you have 2 or 3 different apps that you're doing that for. Then you have your email. Then you have your text. Then you have your WhatsApp. So all of these messenger services, all of that stuff is discoverable information. Now, of course, you have your conversations with AI chatbots that are also, I mean, I don't know where that's going to go.
It's insane. It is fascinating to think about that. What is the limit to which those kinds of communications should or should not be discoverable? I mean, it's almost like, it's almost like a personal diary.
Yeah.
I mean, people use ChatGPT for parenting advice,
for analysis of their health records. I've seen that too.
Right,
I mean,
right.
I think it was Sam Altman that came out and said, I just don't understand why it is that people are oversharing with these chatbots, because none of that stuff is guaranteed to be private.
Right.
Right?
And I think it's because I don't know that people think about privacy in that way. I don't think that people consider that when you are uploading your blood test results to ChatGPT, that document is going into the ether and is now a kind of the property of Anthropic or whoever it is that
OpenAI or whatever it is. I don't know, and it scares me from a litigator's perspective, just trying to advise clients, because it's new technology and courts are all over the place. We were talking about this before.
Yeah.
There was a court in one jurisdiction that made a determination that those chats were perfectly discoverable. Those chats between the lawyer and this chatbot were discoverable because the court reasoned that chatbot treated like a third party. So there was a violation of the attorney-client privilege, okay? Another court in a different jurisdiction said, no, that same type of information, that's work product, because the lawyer in that case was using the chatbot to figure out strategy. So why is that not work product? So I don't know where it's going.
Where do you think it should go?
It depends on who I'm representing.
Right, fair enough. But let's say you were, you were king judge, okay?
Yeah.
And you could fashion a rule around whether or not conversations, let's say pre-litigation conversations with a chatbot, should be discoverable.
I think it depends on the context, right? If you're basically just saying, what are the elements of a breach of contract claim? I don't know that that's necessarily something that should be subject to any privilege. But if you're now inputting and saying, hey, this is my situation, right? And do I have a claim for breach of contract? That's a different discussion altogether. I just don't know where you can draw that line, and it's tough.
It is tough. I mean, I almost think that, I don't know that we want to create a world where people are uncomfortable getting advice.
Right.
Let's start with that. And I understand that getting advice from a chatbot is a little bit weird, but let's start with that, right? in a general litigation context, right? If I'm and I'm thinking about, okay, I have a potential commercial dispute, and I'm worried about, the ramifications of that commercial dispute, and I'm not a lawyer, and I call you up,
Yeah.
okay, and you're a lawyer, okay, but you're not my lawyer at the moment.
Right.
I say, Jose, I'm concerned about this. I'm worried about this, right? And we have a phone conversation about that. And then, sure enough, a couple of years later, there's a piece of litigation that goes on, and I get, sued, or I sue somebody, and I hire a different lawyer.
Yeah.
The odds of that conversation ever being disclosed are pretty much zero.
Right.
It's just not going to come up. But now, people so my Jose might be ChatGPT now.
Yeah.
Right. Actually, I've named my ChatGPT bot Jose.
Did you really?
No.
You really are obsessed with me, so that doesn't surprise me at all.
And so now all of a sudden that conversation and that request for advice, which is kind of just a normal kind of human thing to do, albeit with a robot, but it's a normal thing to do, right? Just say, hey, I'm trying to get my sea legs on this. I'm trying to understand what the right play is here. It feels like we don't want to live in a world where that kind of stuff is published on the front page of the New York Post.
Yeah, I think you're right. And as you were talking, I was thinking that the reason that the privileges that we recognize in the law were created was precisely because they wanted to address those concerns. So what are the privileges? Attorney-client,
right.
accountant-client, priest-penitent, right?
Right.
So all of those things were created, all of those privileges were created for the very reason that you're just saying, right?
Right.
Because you don't want spousal privilege. You don't want to discourage people from speaking to their spouses.
No.
So, or to their shrinks or to whoever it is that they rely on for those private kind of intimate conversations that they're having.
But I guess the linchpin is the expectation of confidentiality.
That's it.
Right?
That's it.
Because when I go to my therapist, not that I have one, but it would be okay if I did.
Right, no, it's totally fine.
My expectation is that my conversations are going to be privileged, private.
Yeah.
But I think that at this point, if I go onto ChatGPT and I communicate with it, the expectation needs to be, this is a public conversation. This is akin to having a conversation with a stranger at a coffee house who gives really good advice.
Yeah, but the problem with these AI chatbots is that they're so pervasive, right? Because the guy at the coffee house might be really good and might know a lot about cars. And then there's another guy at your temple that might know a lot about, whatever the hell it is.
But they don't know everything about
But they don't know everything. But this thing knows everything
everything
about everything.
Yeah.
Right? So it just becomes something that we do, almost like a crutch. I speak to some attorneys and they say, I don't even write an email anymore without running it past ChatGPT because I want to correct it. I want to make sure that the tone is correct. Now, I've done that too, but not with every single email, but you're becoming dependent. There are certain kind of skills that are going to atrophy. So what do? Right? If you're like really nervous that you're going to send an email and it's going to convey the wrong message because now you're conditioned to run everything through that chatbot before you send it.
Yeah.
It's terrifying to think of a world where you're not sending it. So you might say, I don't give a shit.
Right.
Nobody's going to discover this conversation. I'm going to do it anyway.
Yep.
Right?
Yep. No, it's true. It's really interesting, and the law is not going to be able to kind of figure this out fast enough. There's going to be so much, I think, disorder in the legal systems to know what is or is not going to be discoverable, in this context.
Yeah. Think about it. The law never catches up with technology at the same time. Technology is just a beast, right, in terms of its speed. So really, courts are being faced with an impossible task. They're being faced with the task of applying archaic laws in some instances, right, created at the turn of the last century to deal with whatever technology existed then to these new technologies, which couldn't even have been conceived by the smartest, most brilliant person 100 to 150 years ago when these laws were created.
Yep.
So it's concerning. I mean, what's your take? Do you think that they should be privileged? Do you think that they should be discoverable?
I don't think that. Well, so.
And keep in mind that you might be on one side of the coin.
I know. First of all, there's obviously cases or circumstances where communications with chatbots need to be discoverable. Like I just read a crazy story about some guy who basically where the chatbot drove him insane.
Yeah.
Where he fell in love with a chatbot who convinced him to commit suicide.
Right. That was a tragic and crazy story.
Horrible, where this guy, was kind of already spiraling, found solace in, I don't know if it was ChatGPT or Claude.
It was Gemini, I think.
Gemini. And effectively fell in love with this chatbot that convinced him that his body was a vessel that needed to be, that was a shell, and that he would be reunited with this, virtual chat being when he commits suicide. And he did, and he committed suicide, and now obviously there's a civil case about it. So there's obviously circumstances around that where those kinds of chats have to be discoverable because they're very material to the core of it's the stuff of the dispute. I would hope that there's a world in which that there's a way to, again, I think it comes down to this expectation of confidentiality. I think to me that is that's the inflection point. So if somebody knows that their communications are going to be public, or that there's a high likelihood that you do not have an expectation of privacy with respect to communication online with a chatbot, whatever, then I think it's fair to require the discovery of those communications. I'm not sure most people know that. I'm not sure most people would like, if I went over to a stranger and I said, "Hey, you do know, like, let me see your chats with your," they'd be like, "Go screw yourself," like, I mean, plus it's Miami, so, it is a very tough issue. I remember that back in the day when somebody figured out that you can get the
Google searches.
Well, there's Google searches, but even on Xerox machines, where you could find out what was printed on Xerox machines because it stores the hard drive. When you email documents to Xerox machines to print, it stores like the history there, and there was a material issue as to whether or not they were aware of a document or it was printed.
Right.
So you can kind of get that, right? I mean, so there's always been these like little nuanced point, GPS in cars is another thing, right? That people figured out, I can like figure out where somebody was driving because of the GPS. Now, most people would expect that to be private. They would expect that to be something that's not subject to public consumption. So it's a tough issue.
But little by little, the perception has changed, right? So for GPS, you may have had initially, people may have thought, hey, where I go, that's completely private to me. You shouldn't know where I've been, right?
Yeah.
And that becomes particularly relevant, mostly in criminal cases where they're trying to establish where somebody was with, the guy that killed the wife, was he in the vicinity, and they do the GPS. But slowly but surely, there's been a progression where people accept more and more that information is discoverable.
And public, right?
Now, that arguably helps the murderer or the thief be more careful about their crime, but the point is that there's an evolution of the standard, and maybe that's where we're going.
I think my instinct on chat histories and things like that is that I think it's better for the world if that stuff was probably not discoverable.
Yeah.
But I understand that's not always how the law is designed, and I think that right now, as a matter of law, I would expect that most of that stuff would probably be technically discoverable.
Yeah, I agree with you.
Yeah.
I agree with you.
And then, of course, you get into a whole spoliation conversation about that, right? Whether or not you have an obligation to preserve your chat history. If you know enough to ask a chatbot, hey, am I going to get sued for X, Y, and Z? Then whatever that answer is, arguably you would have an obligation to preserve that, right?
There's evidentiary value in the search itself, right?
Yeah.
I mean, that's key.
Yeah.
I don't know how that's any different than, when you send a hold letter, for example, why you wouldn't now include and your chat history.
You should, right.
Right? Because I don't know if you're going to be able to get it at the end of the day, but that may be something that we may seek, and you should be preserving that. So my hold letters now have an addition, and I forget how I structured it, but it'll say, chatbot, conversations with chatbots or the like.
And then it's interesting to think about whether clients' communications with chatbots during a litigation.
Right.
Right. So there's cases for sure that I've heard about where clients are communicating with their attorneys, clearly using the product of AI. Are those communications, and is that chat history discoverable in the course of a litigation, or would there be some argument for work product there?
Listen, I don't know, but we should brace ourselves, because the next 2 to 3 years are going to be a mess as courts try to figure this out until there's like some sort of seminal court decision, opinion that comes out and says, these are the standards we should follow, and then it's well-reasoned and everybody starts following. But until then, I mean, I have no idea where we're going to end up with that.
Yeah, it's fascinating stuff. Well, everybody, it's always a pleasure. Jose, love spending time with you. Thank you all for tuning into this episode of Courtside.
Stay tuned.